what happens is that once we now have safe spaces and we have safe people, we need to know that if something goes wrong, what are we bound by? And we are bound by what I call the matrix. And those of you who have seen the movie The Matrix or the movies The Matrix, you'll know it's an enormously complex thing with a whole set of sort of letters and numbers flowing down in code over a black screen with green numbers. And that is very similar to how our law works. And the idea about looking at it as a matrix is it is a matrix. Things interlock over one another. And if you are going to think correctly about how to intervene and keep children safe within the school sport context, you need to understand how those things interlock because they affect our decision making. So the first thing to understand is that the CAAA is the Children's Act as amended with pending amendments. So the reason I'm a little bit facetious about the fact that it's the Children's Act as amended with amendments is the fact that you must understand that the law is an organic, dynamic thing. It is not static. So what happens is that we recognize there's gaps in our law, we recognize there's changes. So you have to make sure you have the correct versions. And also, as has happened with, particularly within the South African religious context, is when people are unhappy about what the government are proposing, like banning corporal punishment or introducing comprehensive sexuality education. There are amendments around that, and there are public processes by which you can actually participate in those. And we participate in those law reforms all the time. So it's not that you don't have a voice, you just need to keep up with where those voices are. The two pieces, so that's a very, very big piece of legislation. And the two sections you need to know, not know offhand, but you need to know where to find them. You should have them on record. You should have a printout of them on a file in your child safeguarding file, is sections 110 and 150. Section 110 is the section that talks about the mandatory reporting of knowledge that a child has been abused. Now, the important thing is that the first thing to understand is the word knowledge. Excuse the coffee, it's just lubricating my voice at the moment. The first thing to understand is what abuse is, and abuse is in section 150, and there's a long list of things that are abuse. But the important thing for you to understand is that what you must report is physical abuse, sexual abuse, and deliberate neglect. Okay, so physical abuse in our context has become quite complex because corporal punishment must be made unconstitutional. So that has become a real challenge. And then also within the context of sport, if you are giving children physical drills where you are drilling the first team captain of your rugby team who's a super athlete and somebody who's a child who's more artistic or cultural and is not a natural athlete, and you're making them all do 100 push-ups. You know, the idea that they should all do 100 push-ups doesn't make any sense, because the boy with who's the head of the local rugby team may be able to do it easily, whereas the boy who's a more artistic, cultural, who's not a very physical child, he may not be able to do 10. So there's a level at which we need to be careful of the socially sanctioned deviance of sport around the sort of hyper performance and using push-ups and sit-ups as a form of punishment, because there is a level at which that can be physically and developmentally damaging to children. Sexual abuse isn't complicated because it's anything sexual relating to children. Asking for images, sending images, sexual words, sexual sounds, touching children, raping children, etc. And all of those are equally serious. I was recently in a Law Reform Commission working paper where there was kind of this debate about the fact that principals are defining what is and is not serious, so whether it constitutes a transgression in terms of Section 17 of the Employment of Educators Act. All sexual things are serious, okay, within the context of the law. Okay. And then deliberate neglect is important, because deliberate neglect is not, you've got, a family like I have in the inner city, and they are struggling to find employment and make ends meet, and they're struggling to provide adequate housing, adequate fooding, adequate clothing. They're not deliberately neglecting their children. It's systemic. And that is very different from the cases I deal with, for example, where parents put their children on the front seat of a car, they don't put their children in car seats, they don't put the seatbelts on, they're sitting on the parents' laps. The child has, the car has an accident and the child gets injured. Or you have a pool at your home, you don't put a fence around it, you've got small children around, they drown. Or cases I testified in at the end of last year, where children were sort of systematically murdered by their father, stepfathers, mom's boyfriends, and the mother stood by and watched, and were then charged with deliberate neglect and got between 10 and 20 years imprisonment because they did not exercise their duty to actively protect. Now, what is important to know is that if you know a child has been abused, they've told you, there's medical evidence, physical evidence, which you don't find, you refer the children and the parents or whoever it is that's looking after the child to doctors to find the medical evidence. It is witnessed by somebody, okay, or that's sort of like the context where the child has told another child who then tells us as adult duty bearers, because it is not your job to determine whether there is guilt or innocence or whether the child is telling the truth or not. That's the job of the court. Your job in terms of section 110 is to request an investigation. So you're not making an allegation. You're not making an accusation. You're requesting an investigation into the circumstances giving rise to your knowledge that the child has been abused. You report it either on a Form 2. So Form 2 is a direct report to the Children's Court where you request the court to appoint a social worker to a family. And I'll explain when that is most often used in my second form final slide. Or you can use a Form 22, and a Form 22, or you can use both. A Form 22 is a register where we submit the Form 22 to the department. Now, submitting that Form 22 doesn't activate an intervention, because sometimes we offer the interventions to the families, and then we submit a Form 23 to close it, okay? And then the regulation is a Regulation 33, and simply that regulation is just tells you how to use the law. And if you just ask Karen, she'll send you through, which you may have done already, the basic manual with the forms attached to it, which is the minimum standard I'm going to talk to at the end, because there's a minimum standard. Now, if you suspect a child has been abused, you may report it. So in other words, you can report something at any point in time, but knowledge you must report. And if you don't, there is a legal sanction. So it's a fine or imprisonment. And if you do report it, on a Form 22 or a Form 2, in terms of the legislation and the regulation, you can't be sued because you reported it in good faith in terms of the regulations. And what you must also understand is that you are not making a finding, you're requesting investigation. So what you'll do is you'll report what you heard, what you saw. You won't report what you think, because what you think is not relevant to the law. What the child has told you verbatim is what is important. Now, it's significant to note that, and we're fighting this at the moment with the parliamentary thing that we're trying to do on the 27th, during the 16 days of activism, sport is not mentioned. Coaches are not mentioned within section 110. Now, we largely believe that that was an oversight, but for us, that doesn't change your moral and ethical responsibility within the sport context to behave in the spirit of the law, because it's an oversight rather than a way out, if that makes sense to people. Then the next thing to understand is this long acronym, which is the Criminal Law, Sexual Offences and Related Matters Amendment Act. And that piece of legislation is broadly known as the new sexual offences legislation. And that sexual offences legislation replaced the previous one, which was largely the Immorality Act. So it's a very complex piece of law to read. It's written in a very difficult way to understand. And the big thing is for you to understand Section 54. And Section 54 says anybody who knows a child has been sexually abused in any manner whatsoever must report the case immediately to the police. So the Children's Act requires us to complete forms and submit those to the Department of Social Development or the court or both. And if we want intervention, we must ask for it. Whereas the sexual offences legislation says anybody. So the Children's Act is mentioning certain professions. The Sexual Offences Act says anybody. So if you have a sexual offence, there's a dual mandate to report to the Department of Social Development and to the police. Okay, and that is in the form of a police statement. And if you are the first person that the child is told, you'll be required to make a statement, and you will be a witness in the case. So it's important to take notes and write down verbatim what the child has said, not to interpret it, not to change words like stoat things to abuse, not to translate cookie to vagina or whatever. You are not there to interpret, you are there to verbatim say what the child has said to you and then report it for investigation. So again, much like the complexity around corporal punishment, there's a huge complexity around what to report around sexual offences. The basic rules are as follows. If a person does not consent, age is irrelevant. So if you're 0 or you're 150 and you don't consent to a form of sexual contact, you've either been sexually violated or exposed to voyeurism or frotteurism or rape, and as a result, your age is not relevant. Where it is relevant is only children is there a must report clause, and people with a cognitive impairment, there's a must report clause. Adults who report things when they're abused as adults, they can choose to report should they wish to. There's no legal mandate to report. Because this is a school context, it would be, there's always a legal obligation to report to the police to hold a criminal investigation. Whereas the Children's Court activates a Children's Court investigation, which I'll clarify at the end. Then, if a child is under 12, consent is irrelevant. So, for example, I had a man come to me, and he was a stepfather of a 5-year-old, and said to me that he's in big trouble, he needs to talk to me. I said, fine, I need to warn you that anything you tell me, I might need to testify in court about and report. Secondly, I'm going to need to get somebody in as a witness to make sure I've heard you correctly. And thirdly, I need to record it in writing. And if you're happy with that, then I will listen to what you have to say. Because if you don't want to tell me, that's one thing, but if you do tell me, these are my obligations. And I'll say the same to children who want to tell me things, except I'm obviously not as sort of hard. I say to them, you know, I can't guarantee confidentiality because sometimes the law tells me to do things to keep you safe. Okay, and those are, if you're being hurt, somebody else is going to get hurt or a crime is going to be committed. And those are the basic rules. Okay. So under 12, he then said to me, his 5-year-old daughter bounced up and down on his lap. That made him aroused. He asked her, could he have sex with her? She said yes. She's 5. So the court says, you must be mad. You know, how do you possibly think that a child at 5 can consent? Plus it's incest, so you can't consent anyway. But that comes from old Roman Dutch law. So under 12, children can consent to nothing. Over 16, children can pretty much consent to anything that they want to consent to, other than being online, sending images online, because that's all child pornography until the age they turn 18. And then, you know, sorry about the trigger warnings around sort of the next two concepts, but things like bestiality and necrophilia are completely illegal regardless of your age. Now, I mean, it sounds bizarre that I'm mentioning things like bestiality, but I had a report from a religious school this week of a case where images of bestiality were being sent around among a group of 12-year-old girls. Okay, so it's not something that is not, it doesn't exist. In fact, it's rife online. I've had more than one instance online, and I've had cases sort of in the real world where I've had to intervene. So those are completely illegal. Okay, but over 16, apart from online and those two parameters, pretty much whatever young people want to do, they can consent to. So that leaves us then with the age category of children 12 to 16. This is the complex part of the law. So the Sexual Offences Act has been amended, and it has made sections 15 and 16 of the Sexual Offences Act unconstitutional. And those were the sections that dealt with the criminality of consensual sex between children 12 to 15. It is not a criminal offense anymore if children 12 to 15 have consensual sex with one another, provided that both consent to the sexual encounter. The day one of them turns 16, the person younger than them cannot be more than 2 years younger than them. So 12 and 16 is a criminal offense, but 15 and 16 is not. 15 and 17 is not. So the day one turns 16 before they turn 18 and become adults, the other one cannot be 2 years younger than them, otherwise an offense does arise. However, I'm like a very marked advert and the very marked advert, and there is more. The next abbreviation, which is the CJA, determines criminal capacity. So in other words, the person committing the crime can understand the wrongfulness of the act, the consequences of the act, and can act in accordance with those two things. And the Child Justice Act says children under 12, which has changed from 7 and then 10, and it's now up to 12. Children under 12 have no criminal capacity. So they're dealt with in terms of Section 9 of the Child Justice Act, which is a set of therapeutic, familial, and other interventions, but you cannot have a criminal outcome. It's not like in the Jamie Bulger case in the UK, where all movies you see about America, where you can make an application to have a child tried as an adult. There's no such thing in our law for children under 12. Children over 14 have automatic criminal capacity, but it is a last resort that they go to jail. They do for very serious offenses, and I've dealt with children of 14 in prison who are serving 35-year jail sentences. When they become adults, they move them from the children's wing of the jail to the adult wing, but those are very, very serious crimes. Most of the time, what we're trying to do is diversions, and that means diverting children away from the criminal justice system into registered accredited therapeutic programs. Teddy Bear Clinic does one for sex offenders, Sanka does one for drug abuse, NICRA does them for other offenses like theft and shoplifting, Kulisa does them, but they're accredited. That's not your local therapist, they're accredited programs. So then that leaves us with children 12 and 13. And children 12 and 13 are assumed to not have criminal capacity unless the state chooses to prove they do. And I've only in the history of my entire career had 3 times where that has happened, and I've got one pending now. So in my whole career, it's only happened 3 now, maybe 4 times. And that is generally with outside interference, political interference, media interference, custody access divorce cases with the interference of disgruntled exes, etc. It's not what the state wants to do. So if they don't have criminal capacity, they're treated as if they're under 12, and if they're found to have criminal capacity, they're treated as if they're over 14. Okay. Does this all make sense so far? Any questions? I'm going to pause now, because if you have questions, this is the end of the sort of laws and the ages of consent, because there are a couple of others which you need to know but are not essential in terms of your kind of way forward. Okay, so in terms of our constitution, you are a child until you are 18. The age of 21 no longer exists. So in terms of the Children's Act, that first one, when you report things, the reports are all around people under 18, whereas when you come to the Sexual Offences Act, it's up to 16, with the exception of, like I said, pornography. But the Sexual Offences Act also looks at the cognitive age of people. So it also includes adults with cognitive impairments, and those are either temporary impairments, like if someone has a manic episode, or they are permanent impairments, where someone, for example, has a syndrome like Down's, and as a result has an intellectual impairment. So the Sexual Offences Act also considers the mental age of an adult in terms of their ability to consent. And in fact, for those of you working with adults who are cognitively impaired, there is a higher reporting mandate, because for children you have to report knowledge. You may report a reasonable belief or suspicion, but for people with cognitive impairments, you must report a reasonable belief or suspicion for adults who have cognitive impairments. So there's almost a higher duty to protect cognitively impaired adults in the sexual offences legislation. So the age of 21 at the moment is nothing except a key and a party. It doesn't exist. So there's no age of majority anymore. It's a fantastic question, because it's a lot of what we're dealing with within the context of our cases at the moment. So what we have around the concept of consent is is a set of quite complicated things young people are required to understand, which us as adults don't even do, frankly. And then we're expecting children to negotiate them. So, for example, the current guidelines on consent are more or less the following. Number one, you have to be of age to consent. So that's the first thing. Number two, the other person has to be within a reasonable age category to you to consent. So that's the 12 to 15, 15 to 17 scenarios are painted, because there's certain age gaps where you can't consent and there are defined lines. But let's take the ones where you can consent. So that's the 12 to 15, 15, 16, 15, 17, 14, 16. In those instances, the first thing is that the consent is not made under intoxication. Now, that's become a really complicated story for us, because now the intoxication has become common and people are initiating things, not knowing when to stop, not understanding that they were asked to stop. The people who are not stopping the people from the sexual contact are saying, but I did try and say something, but I couldn't because of the nature of the sexual encounter or the nature of my intoxication. And unfortunately, because we know from good neuroscience that adolescent brains are the equivalent of giving unlicensed drivers Ferraris without brakes, add a little bit of marijuana and alcohol to that, you now have nitrous and a turbo on top of this brain, and the ability to make informed decisions is extremely poor. So the first thing is that intoxication assumes no informed consent. So that's the first thing they need to understand. So if you're going to get intoxicated or have a sexual encounter with an intoxicated person, the chance of there being a comeback is high. That's point one. Point two is that consent to one level of a sexual encounter does not imply consent to the next level. And this has become a really, really complicated thing. And I'll give you sort of a case example of that. The next level at which is you can withdraw consent at any point you become uncomfortable within a sexual encounter. That has become complicated, and in fact, let me give you a case example. So within the religious sort of school context, I had a case, and it involved particularly two teenagers within the realm of consent. So they were within the ages at which they were considered capable of consent, and it went through kind of the usual stages of getting involved and hooking up, and then kissing, and then touching, and then it ended up at oral sex. And what happened is they were both intoxicated. And what happened at that point is, due to the nature of the oral sex, and particularly the pornographic script that has become associated with oral sex, there was what was considered to be force and the inability to say no, because he was holding her head and she couldn't talk because of the oral sex. And when there was a disengagement from that, there was a level at which that point she said, I absolutely did not consent to that, but there was no way I could voice that other than just sort of in my body pulling away. And that, because of the pornographic script, because there's a lot of force involved in the pornographic script, was seen as part of the sexual encounter by the intoxicated boy. And that ended up in a massive issue, because that's rape. Because any form of penetration is rape. So now suddenly you've got a 17-year-old boy being charged with rape, where he's saying, but I had absolutely no idea, because the script that he had was one of the pornographic script, and sex being a consumer-based thing, and not understanding that this kind of resistance was a way of denying consent at that point in the sexual encounter, because it got progressively more forceful and started choking her, and she wanted to withdraw the consent in the middle, and he said he didn't understand that. Okay. So it is not so much enthusiastic as progressive. So in other words, it is consent to see that somebody is okay over a period of time during an encounter, because consent progresses along the course of the increasing intimacy and sexuality of a particular encounter. There unfortunately has become a higher burden on our young people, because the scripts have changed dramatically. next abbreviation, the COTOPA, is the Choice of Termination of Pregnancy Act. And I know that is another very big sort of complex issue, along with spare the rod and spoil the child and all the other things, you know, that have religious value basis as opposed to legal basis. But the thing to understand is that the age of a person is not what is relevant for consent to a termination of pregnancy. The term of the pregnancy is what is relevant. So any woman can terminate her pregnancy from the day she can become pregnant. Age is not part of what is considered in terms of consent for an abortion. What is considered is the term of the pregnancy. So in the first trimester of the pregnancy, there is no conditions whatsoever. Anybody can terminate at any level. And I always sort of jokingly say this to people: for the men in the audience, a trimester is the sections of 3 months in the 40 weeks of the pregnancy. So in the first trimester, no conditions. Second trimester, conditions are things like abject poverty, the fact that the mother's life is at risk or health is at risk, the child has a non-viable medical condition like trisomy 18 or something like that. And the third trimester, very much the same, where the child is a product of rape or incest, or the child has a genetically transmitted disease that is seen as incompatible with life. And in fact, I have a close friend who, him and his Catholic wife, were offered a termination at 8 months of their pregnancy when they found out that their child had tuberous sclerosis, which is a very life-limiting condition. So that's a termination of pregnancy, and it's all about option counseling. And then obviously children are not allowed to drink, they are not allowed to smoke, they are not allowed to vape, they are not allowed to smoke marijuana. Marijuana is not legal within the context of children, and all of these mythical creatures around CBT and THC and vaping with things that they call Dutchies, things like canna, they're all illegal, okay, including what parents allow as the slippery slope around the Film and Publications Act, which is allowing their children to play age-restricted games when they're not supposed to, allowing them to be on age-restricted social media platforms, allowing them to watch age-restricted movies, and then they wonder why their children drink and smoke because they haven't paid any attention whatsoever to the fact that our government has legislated ages. All of that should not happen. Okay, it's neglectful and sometimes frankly negligent. So what are we then to do? We are then there to be advocates for the rights of children. We need to observe, we need to listen, we need to communicate, and ultimately we need to be unpacking for children what, who, when, where, how these things happen. We are not there to investigate the matter. We are there to gather sufficient information to make sure we fit our reports and requests for investigation into the categories I've explained in the matrix.